Mr. Lukman, sir, please kindly help us make CJP Ogbala and Co. a host.
Done.
Thank you, sir. Good afternoon, everyone. The webinar will officially start by 4:45. But while we wait for others to join, I welcome everybody and I really appreciate your effort. I appreciate your time. It's not easy to leave whatever thing we are doing and trying to attend the webinar now, especially with the cost of data. Because recently we realized that data has already, in fact, it has changed price. They have increased the price of data nowadays. What we used to buy for 2,000 before, we are now buying for 2,005. So really appreciate you. And we hope that this program will be more valuable than the price you are putting into it. Though the webinar is free, but at least you are buying data to attend. So data too is also a price. So we welcome you. This is the second episode of this legal awareness campaign. We started second Wednesday of last month, which was in September, where we discussed the student rights. It was very, very interesting. In fact, I myself personally, I learned a lot of things. There were a lot of things that I thought I knew that I did not even know. So thanks to our capable barrister that enlightened us. We really appreciate the barrister. We appreciate his effort. We God continue to crown his effort and enlarge his own domain too. So without much ado, we will start now. But once again, for the benefit of those who were not in this webinar last week, I would like to reintroduce our barrister. I'm sorry about that. It was due to network. So I was introducing our barrister, the speaker of today's webinar. So Barrister CJP Ogubara is a chartered arbitrator, tax practitioner with the Chartered Institute of Arbitration, UK, and Chartered Institute of Taxation of Nigeria. He's an expert in energy and environmental law, tax law, and secured credit transaction law. He has published several articles, among which are Bills of Sale and Security Interest as Collateralizing Instrument for SMEs Credit in Nigeria Post-COVID-19 Economic Recovery, Self-Certification as a Tool under the Common Reporting Standard, CRS, in Tax Administration for Aliens and Non-Residents, and Examination of the Legal Status of Consumers and Customers in Electricity Contracts along the Nigerian electricity supply industry value chain, and Awakening Reasoning for Internationalization, the COVID-19 pandemic as a game changer in environmental law. Barrister CJP Ogubara is the founder of CJP Ogubara & Co., Swiss Generalist Advocates, located in Nigeria. He's a seasoned litigation and arbitration attorney and had handled highly contested civil litigation cases up to the highest court in Nigeria. I welcome Barrister CJP Ogubara to today's webinar, and I welcome all the participants. I am the host. My name is Babatunde Odedele. So very soon I will leave the floor for the barrister to take us on today's topic, which says legal awareness on employers and employees' rights. So I believe there are so many things that we as individuals or as citizens, we don't know. Many employers don't even know their rights. Many employers don't know their rights on their employee. Also, the employee does not even know their rights over their employers too. All these things we need to enlighten ourselves. All these things cannot be taught in the school. We can only get them on the field and while we are working. So that's why we organize this program, so as to enlighten ourselves. And as we know that Accurate Creative Mind Foundation is all about enlightenment. Enlightenment, because by the time you are enlightened, to make your life easy. By the time you are enlightened, to make you know what to do and what not to do, which means you will not be falling into problems and your life will be a kind of smooth. May God help us. So I will leave the floor now to Barrister CJP Ogubara as he takes us on today's topic. You're welcome, sir. As we continue, I will expect everybody to mute their mics, please.
Good afternoon, everybody. Good afternoon, everybody. Good afternoon.
Good afternoon, sir.
Like he rightly introduced, my name is CJP Ogubara, a legal practitioner here in the city of Abeokuta, Ogun State. This is the second series we'll be having on the Accurate Creative Mind Foundation Legal Awareness Campaign. This series, being the second one, is titled Employers and Employees' Rights, shortened as Employment Rights. By way of outline, we'll be going through 8 items, 7 items with a conclusion, making it the 8th one. The first is introduction. We have on the second leg, contracts and formation of contracts. The third is this. Okay. All right. Contracts and formations of contracts. The third item is contract of employment. The fourth item is conditions of service. The fifth is trade unions or trade disputes. The sixth is termination of contracts. The seventh is remedies. We'll be taking these items one after the other to be able to understand what it takes. Because when you talk about employment rights, where there is rights, there should be other things existing under the jurisprudence of law. When you talk about rights, you also talk about remedies, as well as authorities, duties, obligations, liabilities, and the rest of them. So now, as well as there are rights, there are also duties. So we'll be taking them together So as we go into the journey, we'll be able to understand where there are duties and where there are rights. First, like I said, we have to have first on the item is what we call general introduction. We need to understand what is employment. What many people call employment is not actually employment. And employment also has to be examined from different perspectives. For example, if you call an Okada man, if I ask you what is the status of an Okada man who is involved in the business of Okada riding, if you're not careful, you would disagree that that can be called an employment. Because the reason why you have that disagreement is because you feel there is nobody who takes the position of employer. And then if I argue from the perspective that it is an employment, you begin to ask me, who is the employee, who is the employer? That's why I identified employment, I identified job, I identified work, I identified, these things are called oro in my local language, and in Yoruba it's called ishe. Then I identified business, I identified establishment, I identified enterprise. These are the few I could just lay my hands on. Now, as we journey, like I said, you will now come to the understanding that even an Okada man, what he is doing is an employment. Because when we get to what we call dispute, trade union and trade dispute, you will now understand why an Okada man is also categorized as, the business of an Okada man is also categorized as forming part of the scope of employment. There is what we call inter-union activities and intra-union activities. Now, when you talk about inter, you're talking about what is happening between employers and employees. Whereas when you talk about intra, you're talking about what is happening among the different employees in a particular sector of the economy. So, job as I am now, I can say I am employed by the law firm of CJP Ogubua & Co, even though I'm the founder, proprietor, and permit me use the word owner. So work, what is the difference between employment? All of them, like I've subsumed them under the term employment. So we'll quickly go to the second item, which is contracts and formations of contracts. Now, what is a contract? As the kind of audience I'm attending to now, I wouldn't go into definitions because there is nobody, if I call on any one of us, I mean, the definition of contracts can be imagined or even given, depending on what you have experienced in the course of life. But there are 4 cardinal things, 5 rather, I will identify. And by the time I identify them, if they are absent in any form of transaction, then there is no contract. But if they are present, then there is a contract. The first is what we call offer. The second is acceptance. The third is consideration. The fourth is intention to contract, meaning intention to create a legal relationship. And the fifth is capacity. Now, offer is simply when I make an offer to Dr. Accurate, I present myself for some medical diagnosis in his establishment, and I now present myself. The moment I presented myself, I have made an offer to be examined medically, diagnosed medically. By the time he asked me to climb or to be put under the needles and the other equipment he uses for his job, he has accepted. Now, consideration is what we exchange, either monetary or any other pecuniary or compensatory givings that I give in exchange for the services he will render to me. Then the intention to create legal relationship or intention to contract. There has to be that mindset that I want to go into contract, that I have come to patronize him, that I have come for me to be examined or for me to be diagnosed. And then the fifth one is what we call capacity. For example, there are a lot of people that when they say they want to buy land for their children, I'm digressing, but it's very important because this is awareness. A lot of people say, I don't want to buy property in my name. I want to buy in the name of my child. That child, what is the age of that child? The law under Land Use Act says clearly that any person below the age of 21 cannot transact in land. So if you are buying a land for a child who is below 21 years, you're on your own. And remember, when we were doing the students' rights, we also identified the age of adults as 18 and above. But now, under the law, the Land Use Act, I think section 22, 21, 22, 23, has now given an age bracket where where somebody below it cannot contract. So these are very important. That's what we mean by capacity. Then another aspect of that capacity is what is the mentality? Somebody may be of age to contract, but what is his mental capacity? When you call somebody that is mentally derailed and start telling me that he has landed property, for example, I see somebody who has mental issue and he has a land in a very good location. For example, a place like Okelewo, and I cornered him and brought him to my office and say, Baba, obviously mentally derailed. You know, I gave him 500,000 naira, Baba, give me your 2 plots of land along Okelewo. There is no capacity. It's just like getting a man who is very sick and at the point of death, bringing him to a corner, to a place to write a will. Or a man who has mental issue and you are bringing him to write a will. The capacity is lacking. Another area is unregistered entities. You know, we have two categories of persons in law. There's what we call artificial and natural persons. For example, I'm a natural person. All the members of this audience are natural persons. Second to it is an artificial person. For example, Accurate Diagnosis Limited, whether it is a business name or it is a limited liability company, it becomes an artificial person. So if you are contracting, there has to be that capacity. If it is you are contracting under as an artificial person, that artificial person must be one recognized by law. For example, whether it is incorporated by the certificate of by the Corporate Affairs Commission, or there is a law that establishes. For example, OOU. It's not registered with CAC, but there is a law creating OOU. That law has given it the power and the legal backing it requires. So that is the area I'm talking about capacity. Now, contract. I forgot to include these areas. What are the ways of contract? A contract can be in writing, orally, or by deed. Now, contract by deed are those we call specialty contract. I wish I can, at the end of the program, I should be able to add that. You know, so we have categories of contract. We have what we call oral contract. We have contract in writing, and we have contract by deed or by seal. Now, a contract by deed or by seal is otherwise called specialty contract. That means it has to be put into deed. A contract can also be oral, whereby I stumbled on Accurate and say I want to do, that's the oral contract. We are contracting, but it is oral. You can imagine when I start writing, just because I want to be diagnosed, I start writing to Accurate, and then he replies me to make an acceptance. You know, that would be, that. I mean, I don't know the kind of industry we will run, making having all our contracts in written form or by deed. I don't know if the audience is following what I'm saying. I want it to be more of an interactive session. Am I too fast? Okay. Members of the audience, Am I flowing?
We are with you, sir.
All right. All right. Thank you. So now, like I said, I was trying to categorize the three categories of contracts we can have. Now, I said it could be by oral, it could be in written form, it could also be by seal or deed. No, now the written form is the one that is in writing. Now the question is this: what's the difference between writing and deed? Now the writing is a writing that can be concluded with simple signature. Now a deed is something that is under seal. In the common law theory, where the idea of deed and seal originated, it's called parchment. This is my deal, this is my seal. In those days, during the medieval history times, the king can put up something by his seal. Once the seal of the king is on it, that concludes it. Right. But when it is in written form, I will just simply write something and send it without a deed, without a seal attached to it. An example of seal is what we see here. This is an example of seal. Which of the systems are you seeing? Am I visible? This is an example of seal. Most of us will have it in our offices. This is another example of seal, iron seal. Now, when a contract is by deed, right, it will be sealed. This seal, when it is impressed on a paper, the mark that will be shown is the mark of CJP Ogugbara & Co. Likewise, this is an ink seal. This is iron seal. This one makes a mark and this one makes an impression. So that is for deed and in writing. Now, oral is when I approach him, no need to write anything. I just tell him, this is what I want. The way you will go to a shop, madam, I need a amala. She says yes, is being sold at so price. And then you also, she gives you an offer. Maybe you say, madam, I need an amala. He said, okay, the amala is sold at 300 naira. She has made an offer to you. Even though you are the first to approach her shop to say, madam, I need amala. Then she makes an offer to you by saying it is 300 naira. You can accept by paying that 300 naira, or you can make what you call counter offer, telling her, madam, I can only pay 200 naira. By the time we journey into this, the subject of our today's discussion, you will be able to understand the essence of all these things that I'm talking about. Now you tell her, madam, I'll buy you 200 naira. If she accepts, now she's accepting on the basis of your counter offer. So you are now the person making the offer. Initially, she made the offer, but initially, you remember, you had gone to her shop. You have gone to her shop. You have gone there for the purpose of showing yourself, but you have not made an offer. Madam, I need amala. You are not just expressing the desire to have something. You have not made an offer. But when you say, madam, I need amala, 200 naira, you have made an offer. I don't know if I'm making sense, please. Hello?
Yes. Hello, I'm with you. Hello, yes.
All right. So when I approach her shop and say, madam, I need amala, 200 naira, direct, I've made an offer. She accepts by either saying, okay, Mowo, bring money, and then she dishes it out. That's acceptance. Consideration is me giving the money. Intention to contract is it's in the mindset. My intention is to buy because there is contract. I intend to contract. Now the capacity is, that I have the mental capacity and whatever age range or whatever to contract. So we'll move to the second, the third item, which is contract of employment. So we are going into the meat of our discussion. Now, when you talk about contract of employment, remember the 5 things we have mentioned as regards to the essentials or in elements or ingredients of a valid contract. Right. So when you now talk about contract of employment, you are saying something different from what I have gone to Mama Yamala shop to do. Remember, the two are contracts. This one is a contract distinct from, you can see, among all the things this I listed here is contract of employment and other contracts. So we'll be taking it first on the list is what we call the contract with statutory flavor. What is a contract with statutory flavor? That is the kind of contract you see in government, public service, civil service. Every establishment of the government has an act or a law or an edict for the local government establishing it. Or bylaw establishing it. In the local government, you have bylaw. In the state, you have law. In the federal, we have an act. So any of these have laws, acts. Call his attention. Is he recording? Be sure. Every tier of government, right, has the kind of employment, that laws that establish its employment system. But we call all of them civil service or public service. The meaning of that, when you talk about employment with statutory flavor, you're talking about employment that statute has created. Is recording. Okay, good. Now, when you talk about, for example, OOU, or is an establishment of the Ogun State government. There is a law establishing OOU. Onabiso Onabanjo established University Establishment Law. I think it was in 2016 6 law. It's contained in the laws of Ogun State 2006. Sorry. So now, upon the establishment of that organization, all the people that are employed there are employed by the provisions of the statute. So we call them employments with statutory flavor. You cannot sack, you cannot remove, you cannot discipline, and you cannot promote, and you cannot remunerate without adhering to the statute that establishes that organization. So the director of a certain level cannot wake up and sack the gateman and say, you are hereby sacked. No, he must reckon with the statute that establishes that organization before he can carry out any activity. So even if he wants to discipline, of course, there is hierarchy. He must follow the law, how the law has marshaled out how discipline should be instilled on the members of the workforce. He cannot just wake up and start dealing with people the way he wants. Or let's say the vice chancellor comes up and says he wants to lock up everywhere. Are you following the law? And nobody will challenge him. No, people have to question, Mr. Vice Chancellor, what are you doing? By what authority are you locking up everywhere? So except what he is doing is backed up by law, then what he's doing is what we can later call ultra virus. And the law in the time of, during remedy, we'll look at it. So now, you can see me mentioning directors, superior, subordinates. Everybody is equal. The only difference is the hierarchy, the bureaucratic system, the arrangement of, this person is in the higher level, this person is the lower level, but everybody is treated as the law has provided. All of them are considered employees of the same institution. So now, like I said, you cannot talk about employment with statutory flavor without talking about the civil public service rules. This public service rules has, if you want to issue query for an employee, you must follow what the public service rules have said. If the public service rule says so misconduct is punishable with query, activity must be queried, this and that. Somebody cannot just wake up, a director cannot just wake up and start querying me because I didn't come to work. Public service rule must state clearly that if I have sent myself from work, then I must be issued, a query must be issued to me for me to answer to the queries. But if there is no such provision, you dare not issue query to me. If you issue queries to me, I will challenge it. So I think it's also part of the things we will discuss in the remedies. Establishment Act, Establishment Law, Establishment Bylaws. Like I said, Onabisa Onabanjo is an establishment of the Ogun State government. Now, FUNAB, which is in Ogun State, is a federal university. It's established by an act of the National Assembly, while Olabisi Onabanjo was established by law of the Ogun State House of Assembly. So also that with all other organizations established under the local government, but theirs we call them bylaws. So now we'll talk about non-statutory flavor. That is the kind I and Accurate operates. That I have my staff, Accurate has his staff. What are the things that are available? Now, company directors. When you look at the Company and Allied Matters Act 2020, you will discover that when you are floating a company, there are people that have special status. You cannot float a company without having a director in it. Members of shareholders are not employees. In fact, they are the employers because they are the shareholders, they are owners of the company. Except where the director also doubles as a shareholder. Then in one case, he's an employee, in another case, he's an employer. So when you talk about company directors, you can have directors expatriates. For example, that Accurate Diagnosis could have Indians brought into the country. These are employees of the company. But when you look at it, they are treated special. For example, if you want to float a company whose job is pharmaceutical, you must have a member of the board having license, pharmaceutical license. If there is no member who has a license, that company may not be registered by CSC, provided the object of the company is pharmaceuticals. Now, even CSC has also moved forward to now extend it to construction companies, or civil engineering companies. You must have a certified engineer with CORE as a member of the board of directors. So this is companies without statutory flavor. You can, when you are employing, right? Like in the statutory flavor, like I said, it is a law that states how they are employed. But that does not mean that letter of employment will not be issued. Letter of employment must be issued. But everything about that letter of employment is, there's what we call ground norm. In Nigeria, the ground norm of all laws is the Constitution. Now, the letter of employment issued to an employee in an employment with statutory flavor is founded or rooted to a particular law, either the law establishing that organization or the act establishing that organization or the bylaw establishing that organization. It will be stated in that letter. There is no way it will not be stated. It must be stated. Now, even in the civil service, there are some adjunct employees that are employed. Like, for example, a director may be given the power to employ somebody that will be either his cleaner or his personal driver. Now that person will be considered in the the person's salary will be subsumed in the emolument and allowances paid to the director. I'm talking about contract with employment with statutory flavor now. For example, the vice chancellor that I was talking about, he may have provision for him to have such, be it personal security, be it personal chef, be it personal chauffeur, you know, all those kind of things can happen. Now, do you say that that kind of person can not be sacked or can only be sacked if under the provisions of the civil service rules or that? No. Remember, their employment is tied to the director or tied to the vice chancellor. So anytime the vice chancellor goes or retires, he goes with them. The vice chancellor is the person who has the power to sack him at that point in time. Why? Because his employment is not covered by the statute. It is just like the employment is just like the employment. Disconnected? You disconnected? Okay. It's just like the employment covered, not covered by statutory flavor. Disconnected. Yes. I want to show that. Please. No, not the code. It's like the internet disconnected. Please permit us. We're having technical challenge. We'll come back to you. This one. So now, when like I was initially on non-statutory flavor companies, and I made reference to my establishment and the establishment of Accurate Diagnosis. Is it a limited or enterprise? Enterprise. So these are people who have established their organizations as private entities. So now you can have what we call employment letter, just like you have in statutory flavor. But here, it is the employer, the owner of the establishment, that determines what he wants in the employment. He wants you to resume work at 7, please, you have to resume work at 7. He wants you to close work at 10, at 8, please close work at 8. Now, the question is this: what if it is not convenient? Nobody forced you to come into the job in the first place. Right. Nobody forced you to come into the job in the first place. You felt you can handle the job, and then here you are, you have to do the job. But if it is not open, is not possible to you, you tell them, no, this is not going to work. I cannot be able to put up this. I need to take care of my kids at so time. And if I'm taking care of my kids at so time, I cannot be able to attend to this. So you have the right to choose either to continue or to take. So now in employment letter, the conditions of work will be stated in the letter. Your role, not that your guy will wake up one morning, go and do this, go and do that. Once he does that, you can say, Oga, please, this is not part of what we agreed, because your role must be stated in the body of that letter. Either it is headed as duties or it is headed as obligations. So what you are going to do in the establishment, so that you don't get employed as somebody who takes out blood samples and end up being the person that is doing scan. So it depends on what you were employed to do. Or here in this establishment, you don't come in as somebody who does the typing and then ends up being somebody who is going to court to do filings. So the work you are coming on board to do must be specifically stated. In Senate climes where things are done properly, there's what we call overtime. Or extra work. If you are being engaged by your employer to engage in extra work, the employer must pay for it. If you are doing work beyond the time that your guy has stated in the letter of employment, you can ask for what they call extra hour, overtime. So that has to be stated clearly. Now, when your guy is giving you employment letter, you can say, sir, please, can we have a particular clause stating that anytime I work beyond time, this is what I'm entitled to. Or you set it clear that this is the time I'm to close work. And if I'm staying beyond this time, I will be paid for my overtime. You have the right to demand for that as an employee. So there's what we call probation. When you are employed, but you don't find that in the employment with statutory flavor. But the employment without statutory flavor, you can find it. You can employ somebody for reasons best known to you and put the person on probation. And then that probation, you can put the person to be on probation for 6 months, even with pay. But within that window period, it's just like what they call moratorium for those who are going for loans. You are given the opportunity to be able to do something before you start repaying the loan you have collected from the bank. But in this one, probation period, you will be paid. But at that point in time, the Oga can wake up and tell you your employment is no more needed easily. And if such words like probation for 6 months subject to confirmation, if after 6 months, your Oga did not confirm your employment, you are out of it. Now, similar thing happens to employment with statutory flavor. Like I mentioned, I said the probation as regards to without that word, subject to confirmation, does not apply. Subject to confirmation applies to employment with statutory flavor, but so leaving it without such this thing. So that's for probation. Like I said, if it is subject to confirmation, then we can see such a thing in the statutory flavor. You can hear so many workers when they are employed, and they will tell you, what if they have given us employment letter, what is remaining confirmation of employment. That employment, if it is subject to confirmation, must be confirmed before you can call yourself an employee of that organization, especially for organizations with statutory flavor. Now, for organizations without statutory flavor, Yes, it can also be subject to confirmation. So if it is subject to confirmation and the employer, both in both cases, whether statutory flavor or without statutory flavor, there is no confirmation. Automatically after 6 months, you are going home. But in the one without statutory flavor, your guy can orally tell you, I confirm, go on. But you hold his word for it. So that when you are going for remedies, you can say he orally confirmed it, but it is usually advised that it takes you nothing to request your boss to put together just one-page document. I hereby confirm the employment issued to Lagbaja on so date, after having exhausted the 6 months probation. 2 lines, 3 lines, and that's it. Your employment is confirmed. Now, we talk about employment and agency. When somebody contracts you as an agent, are you under employment? The answer is yes. The answer is also no. So it depends on the presentation of the contract between the principal and the agent. There are instances employment can create an agency relationship. In that instance, the employee is the agent, and the employer is the principal. I'll give you an example. An example is when somebody contracts, for example, a situation like NNPC now. NNPC may now has an organization whose duty is procurement of certain things, maybe to employ staff, to procure materials, to do this, to do that. Now, remember, that subsidiary organization of NNPC is in the first place, is a subsidiary, is an employee of the employer, which is NNPC. There is also another instance, the federal government and any establishment. Now, the federal government can authorize the university to employ the Federal University of Agriculture, FUNAB, to employ workers. So instead of the Ministry of Directorate of Employment to come in and employ these workers, this organization, this FUNAB cannot employ the people they deem fit. For example, if they want to employ lecturers, it is them that will advertise. After they advertise and those lecturers apply, and then the federal government will now be, of course, the federal government is the employer ab initio. And now you have also had another employer, which is the university, to that lecturer. The lecturer is an employee to the federal government as well as an employee to the university. So I had to identify this agency so that it will be clear. So at that point in time, who is an agent, who is an employer, who is an employee? So you see that the university management, who are the employees of the federal government, have also invariably become agents employing other employees for the federal government. Similar thing with Onabiso Onabanjo University in the state. So the next is what we call contract staff. That is the order of the day today. Now, banks are the ones prone to this. It's a wizardry that certain lawyers came up with and advised banks, and they saw that it is very, very crucial. It is very, very good. Now, a bank employs normally, but these days they don't employ directly. There is a reason, and the reason I'm going to tell us now. Privileged for understanding and for knowledge, so that as we are going into our workspace, we'll understand so many things that are happening. Now, a bank contracts XYZ company to employ. XYZ company employs Lagbaja, employs Bamidele, employs Oladele, employs Babatunde. Now, this company, this XYZ, now deploys or redeploys Lagbaja, Babatunde, Tope, and the rest of them to the bank. In the mind of these workers, they are working for the bank. But by the time you review your employment letter, you discover that you have no business with that bank. Now, why is bank resorting to this formula? They are running away from liabilities. Two. But there are things good about this kind of thing, this kind of platform. It gives the bank the opportunity of getting the best, because this XYZ would have employed the best to be able to protect its integrity in the workforce, in the chain. If tomorrow they bring in people that are incompetent, the bank will raise alarm, and another bank company will not contract them for such. But by the time the bank keeps saying, the people you people are bringing on board are good, right? So the bank is looking for a way to minimize its costs, its exposure to liabilities. So when you now suffer injury in the course of your employment, for example, robbery incident happened and the staff was shot dead. Now, some of these deceased employees, their relatives believe that since it is bank, there is a windfall. They tend to go about dragging these banks, trying to claim Eldorado, whereas there is none. But they never knew that their loved one, their deceased loved one, was never an employee of the bank. It was only deployed to that place. What do you do in that kind of instance? Now, that is where I will share a privileged information. I'm going to share something before I continue. Let me stop sharing. Then I will share this particular paper because it's a client's case that I handled on this kind of, I will use his case to explain something, NIC. Let me just open the statement of facts. Take a look at this. What you're seeing is Mr. Fadairo Oluwa Rotimi Boluwaduro versus Wyclone Limited and Medlog Logistics Services Limited. Now, my client, being the claimant, we didn't go to trial. When I filed the case, they saw that, well, the company saw that they are not going to have any headway. They quickly called us and settled. We settled out of court. But I'm going to paint a scenario that happened in this case. Hello. So in this case, my client was employed initially by number 2 and as a professional truck driver. Now, number 1, the number 2 seconded him to number 1. Now, in the mindset of a lawyer who didn't understand, he would have quickly rushed and sued number 1. But the letter of employment was able to establish that number 1 is actually a third person. So what you do is you sue the 2 of them so that you will have jointly and several claims against them. So now the injury my client was complaining was committed by the first defendant, the number 1 defendant. But there is no contract. But don't forget, the law says where there is right, there is remedy. We say it in Latin word, ubi ius, ubi remedium. So where there is right, there is remedy. Where there is wrong, there is also remedy. Where there is injury, there is remedy. So if you commit any injury against me, there should be remedy. So we also came under that. So you see that there is ample opportunity for an employee to claim and have a respite in the court at the end of the day. So we'll go back to our discussion. So now that's what I said third party arrangement. So the bank now gets a third party who now hires staff and bring them on board and second them to the bank. So when issues come up, the lawyers, if it is the lawyer that doesn't understand, the lawyer rushes to go and sue the bank will file what we call preliminary objection. Say, I don't have any contract with this gentleman. Why is this person suing me? It's called no cause, that your suit discloses no cause of action. So if there is no non-disclosure of cause of action, then the court will throw away the case, because you cannot go about suing people. The fact that you came to my premises, you are working there, doesn't mean I'm your employee. Show me proof that I am, doesn't mean that I'm your employer. Show me proof that I employed you. So that is the arrangement these third party, these banks have, some of these companies have resorted to. It's called contract staff, third party arrangement. So now, contracts of employment and other contracts. Like I painted earlier, I said I walk into Mama's shop to buy amala and ewedu. That cannot, in a reasonable balance, be considered the same with the contract of employment as we are discussing. So what relationship does employment create? It creates master-servant relationship. Whether it is the employment with statutory flavor or employment without statutory flavor, the two of them recognizes the relationship as master-servant relationship. And of course, we understand what it means to have master and have servant. So now, conditions of service. You cannot have somebody coming, resuming every day and leaving every day without conditions. There has to be condition of service. That condition of service, I've also recognized this as consideration for the employment. Is the consideration element of the elements of a contract. Now, in employment, we have considerations such as salaries. We have what we call wages. We have generally, they are called remuneration. Now, remuneration can come in the form of salaries, which is monthly pay. It can also come in the form of wages, which is weekly or daily pay. When it is in the form of wages, or it is either weekly or month or daily. But when it is in the form of salaries, it is either annual or monthly. So now incentives, there has to be incentives. These are the considerations that an employee enjoys from his employer. Incentives such as if you sell so number of, I always accurate diagnosis services. If you are able to scan 50 pregnant women in a month, you as the head of scanner section, I don't know how it is done, but I'm just giving you a picture. You will be entitled to 10% of all the proceeds. If you're able to conduct tests, blood tests on 50 malaria patients, you are entitled to 10% of the proceeds. These can be incentives. Now, for employment, there has to be good condition of service, such as housing. You can't employ somebody you don't consider where the person comes from, where the person sleeps over. Now, housing can be the obligation or responsibility of the employer, directly or indirectly. Indirectly, where the salary, we call it basic salary with all other things going with it. Even if you are being paid 30,000 a day, the basic salary could be 20,000 or 15,000. Transport allowance is there, housing allowance is there. Housing allowance could be 5,000, transport allowance is 5,000. Put it together is 10,000 plus your basic salary is 20,000. So, but every employment must contemplate the housing. housing must be contemplated in every employment. That is why most governments, if you go to housing, you see quarters. In some secondary schools, you see teachers' quarters. Housing is very, very fundamental in employment. Whether employment statutory flavor or non-statutory flavor, housing is basic. So you can provide the housing or you can be part of the salary. For example, I was discussing with somebody and I got to understand that Precious Pharmacy, there is a particular outlet of theirs where they have housing, accommodation for each staff. Now the staff are paying. They are paying the company for it. Another area is Korede Hospital. They have their staff, some of their staff, the residents in that place. So you discover that housing is an integral part or integral element of employment because employment should be welfare driven. Welfare, if you are not interested in the welfare of your employee, your employment will suffer it. Your establishment will suffer it. Because a depressed person will always produce very bad output. So if somebody's welfare is not paramount to the employer, then he is the person losing, but he doesn't know. Sometimes we don't have to use what is obtained in Nigeria to justify or analyze what these things are all about. Most times, Nigeria, their system can be chaotic. They try to go outside what the law says. Now, tools. Conditions to service will require tools. I mentioned stationaries. You don't expect the employee to be buying biros like what we see in the civil. I went today to renew my driver's license, not driver's license, vehicle particulars, and I discovered that the printer wasn't working. At IRS, okay, Moso. So I was tempted to come to my office here, carry a printer and said to them there so that they will be able to print. But as on a second thought, I said, what is all this? How do you expect the lady or the man who is there sitting on the desk from morning to night to be able to be productive when the tools are not available? You hear about stationaries are missing, no paper, you hear about no computer. In this age and time, people still use typewriting. What kind of production output do you expect? Now, there's what to call back end. There's what to call storage. A typewriter doesn't have storage device. So how do you get productive output when you are not getting or putting up your staff, your employees with adequate tools to work? Now we'll talk about research and development and establishment. In our universities, right? Universities are expected to take care of the research and development of being carried out by its professors. It will shock you that in Nigeria, when COVID broke out, some of our lecturers were tasked to go and produce vaccine that can bring that can overcome COVID, bring vaccines that can overcome COVID. They all buried their heads in shame. They were waiting for abroad, where they think things are done well. So in as much as we are talking about the rights, duties, we should also talk about our obligations. Now, universities are expected to turn out resources for research and development. If you are not researching, if you are not developing your office, research could be research, development could be development. Now, you come to my office today, there is no cushion where people can sit and relax. Tomorrow, you will not come. But when you come the next day, something brings you in and you discover that there is a cushion where you can sit, a sofa where you can sit and relax. Definitely tomorrow, whether something is pressing or not, you would like to come and have a relaxation. So this is development. These things are very important. Now, reimbursement. When a staff or an employee makes expenses or expends money in order to actualize the services the establishment is putting out to the public, that staff is entitled to be reimbursed for the money spent. How do you expect a staff to use his money or her money to go and do something for the office and pay out from the salary you are paid? That is not proper. That staff is entitled to reimbursement. So when you expend money on behalf of your establishment, raise an invoice and give to the principal, the employer. They should be able to reimburse you your money. But make sure that you have receipts in backing up to back up what your claims are. Receipts are important to be able to get your reimbursement. Now, let's go to disciplinary measures. There has to be discipline in workplace. Now, even in contract, in employment with statutory flavor, there's disciplinary procedures. Like I told you, the disciplinary measures has to follow the procedure laid down by the civil service rules or by the establishment law or act or bylaw. If the law has established how certain committees should be formed to be able to look into this, those committees must be formed. They must be constituted. And of course, like I discussed the other day, as regards to the rules of natural justice, that is fair hearing, you have both sides, and autem alteram partem, do not be a judge in your own case. All those rules of natural justice must be observed in carrying out disciplinary measures in an employment of statutory flavor. Now, similar thing with employment without statutory flavor. I can discipline my staff. I can suspend my staff. I forgot to include here, one of the disciplinary measures could be suspension with pay or without pay. Now, there was an incident that played out when Buhari was the president. All of a sudden, he suspended the CJ and then Onoge. Now, questions were asked. Do you have right to suspend? Do you have right to remove? Now, there were disputes whether the president has the power to suspend or whether the president has the power to remove. Be rest assured that removal is not the same thing with suspension. Suspension actually is a temporary action of removal. When you suspend, you have removed temporarily. But when there is an outright removal, which is by way of expulsion, by way of retrenchment, by way of sack, outright sack, that is permanent removal. So these things need to be understood properly. So there has to be disciplinary measures, and to discipline is within the ambit of the employer, except he delegates a superior employee to discipline the younger or subordinate employees. But every disciplinary measures are within the exclusive preserve of the employer, be it in a statutory flavor or without statutory flavor. Leisure and holidays. You cannot work and kill yourself. When you're working, you should be given opportunities of holidays, break, and other leisures. You cannot have somebody work from Monday through Sunday. That's not good. Even the law recognizes Sunday as a public holiday. Saturday, some people observe Saturday as public holiday. So these are the rights, privileges of employees. They are entitled to leisures. They are entitled to holidays. They are entitled to salaries. They are entitled to housing. They are entitled to incentive. They are entitled to commissions. Duties. An employer has a duty to provide the tools for work. There must be tools, and it must be made available by the employer. So now we'll look at protective legislation. Now, in the protective legislations, I'm going to give you, like I love using case study, and I will always use cases that I'm handling here. And of course, I will not be exposing my clients, but of course, what you will see is where the law permits me to show in order to be able to educate the public. And that's what I'm doing. So I will take you to a case that I handled before I go into protective legislations. The case of Ayuba. Yeah. Now, let's go to this case. Okay. Sharing this one. All right. Share. Now, when you look at this case, is Goodwill Ceramic FZA and against the Goni Joseph Gwandu. This man is the father of a deceased employee of the defendant. The boy was working for Goodwill Ceramic. Everybody, you all know Goodwill Ceramic. It's a popular company in Agbara. He fell from the rooftop, smashed his head, very sorry death. He died instantly. He died, well, they said they took him for first aid and took him to hospital. Before they could get there, he died. The father sued. This is final address that I wrote. I sued the company on behalf of the father. I represented the father. What the court awarded in this case is 50 million naira. Now, this opens an understanding of what I want to give as regards to protective legislations. Protective legislations. I mentioned Workmen's Compensation Act. It has now moved, and before Workmen's Compensation Act of 2004, but it has been repealed and replaced with Employees Compensation Act. I will also look at Factory Act. Now, in these two acts, I will be making reference to Section 1 and Section 3 and Section 13 under remedies. That's why I discussed it. Now, the law says Section 1A says, provide for an open and fair system of guaranteed and adequate compensation for all employees or their dependents for any death, injury, disease, or disability arising out of or in the course of employment. Now, what is important is in the course of employment. Where did your loved one die? Not somebody that went to do his own thing and died there, and then you want to heap it on the employer. It doesn't work like that. The operative thing is that the person died in the course of employment, in active service. I hope you all saw the provision I'm talking about. It says in the course of the employment. Now, another important section that I took up is the section that forbids exploitation. It says no employee shall agree with his employer to waive or forgo any benefit or right to compensation. Now, in my case, this is what happened. That's why I have to bring this case to your attention. They lured some people. Goodwill Ceramic. They gave the people 1 million naira after the boy died as burial. When the man tried, the man met somebody, and the person referred the case to me. A friend of mine in Bombay called me. He's also a lawyer. He said, please, I should help him handle this matter. I said, it's a difficult thing, but I said, no problem. Because it's a Nigeria is involved, and the Igbo people are involved. I will be very, very emotive because judges are human beings. To go, wow. And judges are human beings. We really have a short time, so let me quickly rush it. So when I got into this case, I came to the understanding that they have given these people 1 million. I said, no, even if you have given them 1 million, it is not sufficient to compensate the family for all the losses, because this boy was trained in school. He has younger ones that he would have been able to take care of for the father. So in that light, the court was able to discountenance with that 1 million, because the section 13 that I'm stating now has stated that no compensation of any kind should stop the court from going further to award compensation. So that's for protective legislations. Now, Factory Act. The Factory Act makes it mandatory that every employer must provide tools of employment. It's one of the cases laws I used in that case. I said, look, this boy, you didn't give him helmet. This boy, you didn't give him other safety tools. No, because even where he was dead, in the picture there, the helmet was not there. That's why his head broke, scattered. And then there was no envelope, glove, and some other safety belts. So these things, the Factory Act makes it mandatory that employers must provide them. Now, trade dispute and trade union, very important. Like I've earlier stated, inter and intra, they are not the same thing. When it is inter, it's between employers and employees. When it is intra, it is between employees. You hear about NASU, you hear about road, you hear about road transport and road workers. So these are union people that are working, they are the employees. They can have dispute. So when disputes arise between them, it is called intra. But when it is between them and their employers, it is inter. So bargaining process, we talk about collective bargain. Collective bargain is allowed, whereby all employees can gather together and push forward for a common benefit, either by way of remuneration, by way of condition of service, by way of, and the rest of it. So this can also be joined by employees in an employment of statutory flavor and employees in employment of non-statutory flavor. Now, part of the things we see in trade union and trade dispute is industrial action, which could be strike, lockout, and the rest of it. Now, are you as an employee allowed to be a member of certain associations? Of course, you're allowed. In fact, that's the essence of trade union, because it's all about your interest. It's all about your welfare. That's why I use the word welfareist associations. Can you join? You can. It's your duty. It's your right. No employer will stop you from joining any organization, especially if it is trade organization or association. So, we now talk about termination of contracts. Employment with statutory flavor, we can have what we call retrenchment. We can have what we call redundancy. These are ways of terminating the employment of people that their employment is under the statutory flavor. But employment without statutory flavor, you can have what we call sack letter. An employer can come up one morning and say, I'm downsizing. Like during COVID, we saw a lot of it. Now, another concept we need to look at is salary in lieu of notice. Like I said, when you are given your letter of offer, right, it can be stated there that if you are free to terminate. Other of the parties, both employer and employee, can terminate. But you can have what you call notice in lieu of salary in lieu of notice. But you as an employee, you must give your employer notice before you quit the job. But if it is an employer can pay you 1 month salary in lieu of notice. If he fails to give you notice of his decision to stop your work next month, he can pay you next month's salary. So that's what we call salary in lieu of notice. Now, there's what they call concept of hire and fire. Now, recently in 2015, the National Industrial Court said no employer, I'm talking about employment without statutory flavor, like Accurate Diagnosis, CJP Ogugbara and Accurate Diagnosis, that have the power to hire and also the power to sack. Now, in such employment, I have the power to hire. I also have the power to sack. That's what the law is. But suddenly in 2015, the National Industrial Court came up and said, no, you cannot do that. Under the concept of hire and fire, a particular case of Aloysius versus Diamond in 2015, it says it is now contrary to international labor standards and international best practices, and therefore unfair for an employer to terminate the employment of its employee without any reason. But when the case was analyzed and later a similar case came up and they went to Court of Appeal, in the case of Oak Pensions Limited versus Olayinka in 2017, the Court of Appeal said no, what the National Industrial Court said was wrong. If I have the right to hire you, I also have the right to fire you without giving you any reason, because you didn't start the business for me. So that is the position now for employment without statutory flavor. Are you entitled to compensation for the employer sacking you? The answer is no. The only thing you can get is salary in lieu of notice. If it is what you are going to court for, you can get that awarded to you by the court. But if in the course of terminating your employment, your employer makes a derogatory or defamatory comment, you can get compensation. You can sue them for libel or for defamation. I have an experience, a certain Jide Taiwo, an employee of Jide Taiwo. Instead of Jide Taiwo to lay her off quietly, they went and communicated to all their clients that this person is a thief. You can imagine the kind of damage they have done to the identity of this lady. She didn't proceed to court, no doubt, but if she were to go to court, that is very, very actionable, and she will be entitled to full-time packages of damages. So in trade dispute, in labor issue, in employment issue, we look at first the courts and tribunals and arbitration. You can resolve disputes in labor and employment at the court, at a tribunal, or through an arbitration. Right. So if there was an unlawful termination, that will only apply to statutory flavor. An employment without statutory flavor does not entertain unlawful termination. There is nothing like unlawful termination. The only thing that can arise without statutory flavor is in the course of termination, there was injury to your identity, to your name. For example, the one I mentioned that Jide Taiwo did. Now, damages, injunctions. These are remedies that can be found in employment cases. For example, you saw that when the labor union wanted to go on industrial strike, the federal government was able to get injunction against them, restraining them from going on that. Those are some of the remedies that are available. Now, you can also have compensations when the federal government or your employer fails to do what they are supposed to do, as stated in the term of employment. You can go to court and get compensations. So you can also, if your employment was wrongly terminated under the statutory flavor, you can have what to call either compensation or reinstatement. It can be reinstated by the court. So what is the future of labor law in Nigeria? This is our conclusion. It is very, very important for us to look at this. You see, there are areas of interest that have international best practices adopted or domesticated into it in Nigeria. Labor is not only practiced in Nigeria, it is a universal concept. Employment is a universal concept. Now, what are we expecting? You see, like I mentioned, there should be housing. You cannot employ somebody you don't know about their well-being, insurance, housing, insurance, retirement benefits, this and the rest of it. Those things are very, very fundamentally wrong. If you want to have good employment system in Nigeria, you will also go and do what we call revisiting the employment laws. I mentioned that it is important for Nigeria to go and consider the International Labour Organization conventions, especially the one that deals on termination of employment. It will help us to be able to understand I mean, that National Industrial Court case of Aloysius versus Diamond, that was what the court looked into before arriving that you cannot fire and you cannot hire and fire as you please. But Court of Appeal has reversed it. Do I agree with the reversal by the Court of Appeal? Technically, I don't. Because the reason why I don't is this. You see, in our system, in our setting, there is what we call exploitation. Employers tend to exploit employees. It could be sexually. And now when an employee sees that advances are being put across, nothing stops two adults, consenting adults, to have love, to be lovers. Nothing stops it. But when the employment becomes the basis of the agreement, then it is being compelled and it should be checkmated. Because when that young lady or young man, because it can happen both ways. These days, a lot of women exploit young men sexually. It's happening. I've seen several cases. It's not something I will start sharing the cases here. Letters are written. I've seen sexual harassment from a lot of women on male employees. So in that case, the employees usually do not speak out because they believe that this person has the power to hire and has the power to fire. So looking at that basis, you can now see that it is important to have a revisit of our employment laws. So I want to stop here. I think I've exceeded my time. And I thank you all for being part of the discussion. It's now time, I think, for question and answers. Thank you.
Thank you very much, Barrister. Really appreciate all these facts that you are just dishing out to us. I would have loved to just summarize some of the things you have said, but because of time, I would not want to let us spend much of the time on this. So I would just want us to ask our questions. If there are any gray areas, some things that I said that may not be clear to us, you can ask now, maybe by raising our hand or typing the question in the chat section. So let us do this as soon as possible. If you have any question, if you have any question, kindly raise your hand or type the question in the chat box section. Any questions from the members? I have some questions here already, sir. All right. Okay. Question number one is that, like the case of data who is cited, that maybe their former employee left and they now started sending messages around that she's a thief and who. What if that person? What if that person is, let's say, guilty of the offense? Is that still a defamation?
You see, in a case of defamation, there's what we call exemptions or justification. Now, when somebody brings a case of defamation against you, one of the defenses you're expected to raise is either justification or truth. Now, if there is truth in what you're saying, then that is justification, and justification becomes a defense. So if she has stolen and you are now informing the people, in fact, that is a responsibility on your part. So inform your clients that this person is a thief. So if she threatens you with defamation, you tell her, but what you did is correct. But we are talking about where employers usually want to intimidate. For example, the young lady in question wanted to leave Jide Taiwo to form her own property business. So Jide Taiwo felt this person has gone deep, and if she establishes that kind of business, she would take away their clients. So they now use that to malign her. So in that instance, you know that it is not true. So if you are saying, if you are pleading justification, you come and establish it. So you can only establish. I have there is a school, Sophia Lakwite at Olomore. An incident happened there recently. And I told the proprietor, I said, look, get this person to write an apology letter. In the apology letter, let it be admitted that she did something like this, so that you have a permanent record of what has been done. Tomorrow, if by any chance somebody seeks your opinion on about the conduct of this person, and you give an innocent opinion that, look, I dealt with this person in the past and I was disappointed because this person stole from me. If the person goes ahead to say, you are this, you are messing up my name, you are defaming me, please, this is just justification. You wrote this, you apologize, and you admitted. So, but make sure that whenever you are having such issue with employer, get proof, have proof to be able to establish or expatiate your defense of justification and truth. So truth and justification are defenses to defamation. I don't know if I have answered it.
Thank you for that clarification, sir. The second question here is that, what is your advice to some employers or employees that have a contract without any written documents? This person says that there are some employers who just, you can work with me, come, just start working. No application letter, no employment letter, they're just working. Are there any risk? And if there are risks, what is your advice to them?
You see, you cannot eat your cake and have it. Now, if somebody says, come and work with me, that person doesn't hate you, actually. He loves you to bring you in. You see, employment is a relationship. That's why I went to put it master-servant relationship. It's a relationship. And relationship is always positive in nature. Now, it is beneficial to both parties, symbiotic. The employer is to benefit because his business will be moving. The employee is to benefit because he will be remunerated. Now, if that is the case, it is very, very important for us to understand that when an employer approaches you and says orally, come, sir, please, this is beautiful. I will appreciate if this our contract can be put into writing. If he says he doesn't know how to write, he cannot be able, you yourself put it down and give him, sir, look at it. If it conforms to what you want. But make sure, for the purpose, because you cannot eat your cake and have it. If somebody employs you orally, he can also sack you orally. And if he tells you that this is, I will be paying you 50,000, he can wake up one morning and say, I will not be paying you 40,000 again. You say, but you said it's 50,000. No, I didn't say it's 50,000. No, I said I will be paying you 40,000, but I will not be paying you 40,000 henceforth. I will be paying you 30,000. From 50,000, he has on a corner moved to 30,000. So you cannot eat your cake and have it. And an employee and your employer can tell you, resume 7 a.m. orally, close 5 p.m. orally. And then in the course of a dispute, he said, no, show me proof where I told you to be closing by 5. So let your relationship be put into writing so that there will be mutual understanding, mutual respect, and symbiotic relationship in that place.
Thank you so much, sir. That was really, really helpful. Then the next question here, sir, says that if a former staff of an organization leaves an organization and now wants to go and start his own or her own, very close to the organization he or she left. Under the law, is there anything that can be done?
Now, you see, this is where the employer has some rights. You know, we've been talking about rights, duties. This is where an employer has some rights. A lot of employers, I'm opening people's eyes now. A lot of employers make terrible mistakes. Now, here's what we call non-circumvent, non-disclosure agreement. Now, in non-circumvent, non-disclosure agreement, you usually will have that after this person leaves this employment, he will not use any benefits, be it clients, be it tools, be it name, identity, information derived from working in the former employment until after 5 years. Employers make the mistake of not having employees commit themselves into this right. You must commit that person into signing that agreement. It is part of employment. It's allowed by law. Because throughout the period he will be in your employment, whatever information that will come into his possession or that he or she will come in contact with, you are not going to remove it from her. So the only way you can catch her is to give her to what come under what the law allows, non-circumvent, non-disclosure agreement, which makes it compelling or compulsory that she will not or he will not make use of those intellectual properties till after 5 years. Even if another company employs him or she should not divulge it. If she does, it is actionable. Now, part of the things, clauses that we usually have is within the radius of 20 kilometers, 10 miles, your business should not be located within that 5 years period. It can happen. You can have those clauses in your agreement. Is employment. Employment is a very serious thing, but people don't know, especially for employer, because a lot of employers will spend money into, I mentioned research and development. So you don't expect me, after putting my money and resources, developing you, carrying out researches, and those researches, I may not even have time to bring in more people for you to train. I trained you, carry out research, you developed, and suddenly you are putting up. No, the law recognizes those rights. Employers should be able to commit employees. You must sign. Must. Unless that contract was not presented by the employer. But once the employer presents it, must be signed. If you are not signing, don't come in. The way you are taking the offer letter, the conditions of service, it can form part of what is contained in the offer letter. And I usually advise employers, when the person is accepting, let the person accept and sign on each of the pages of that employment letter. So that you will not say somebody imported the clause. I witnessed such a thing. The guy, I prepared the non-circumvent, non-disclosure agreement. Yes, the guy said nothing like that it was imported. A pharmacist, that it was imported. I said, what was imported? Stupidly, he didn't know that he signed each of the pages. So, but because the one I put in court wasn't that clear, it was faint. So the areas of the signature for both him and his employer didn't show. But he didn't know that I made him sign in, because I usually say, right, sign your short. I have short signature. I have long signature and I have short signature. There are places I will just sign my short signature. My signature is this, but the short is JP. So I made him sign a short, but he forgot. And because it wasn't clear, when it was time for trial, National Industrial Court, Ikoyi, I brought it. In Business Boss, I showed him, you have short signature. He said, yes. Can you sign it before the court? He signed it. Good thing, he signed the same one. And I presented it to him. Who signed this? He denied. He said he didn't sign it. The court just looked at him and cautioned him. Don't come here to mislead anybody. Do you understand it? So if those very, very important steps were not taken, he would have said that it was imported. And when he says it was imported, you are at a very difficult position because you have to prove that it was not imported by bringing in witnesses. And what if there is no witness available? And in case you have progressed into that case, you will now go and start amending your processes to bring in witnesses. So it is important to have those clauses, right, included in the employment letter.
Thank you so much, sir. The last question that I have here is this. When we were discussing, you told us that at the point when a new employee wants to accept, maybe sign the employment letter or offer an acceptance, you can tell the employer, please, whenever I spend more time in the office, you should compensate me. Whenever I do this, you should do this, you should do that. Why won't it be stated too that, sir or ma, whenever I come too late or I come late, my salary should be deducted? Is that mean on the side of the employee now, or can you shed more light on that, sir?
Now that comes under what we call disciplinary measures. You know, I stated it. You could suspend. You could also withhold salaries or deduct. Now, when a staff, when you are issuing, I would have loved to share a copy of letter of employment that is here, but we have to locate it now will be a difficult thing. When you are issuing out the letter of employment, there is what we call obligation, duties. Now, it is the obligation of a staff, an employee, to be punctual. If the resumption time is 7, and penalties stated, penalty for not even coming at all has a penalty. Now, coming but coming late has also penalty. There are some people that the penalty they include is deduction of the salaries or wages, depending on what the person is earning. If it is weekly wage, if it is weekly wage, if it is monthly salaries, those deductions will have to be, but it has to be stated. You see, employment is a serious business. We are busy here. That is why employees suffer it. Employers also suffer it. Now you have, okay, she's closing now, but her closing time 6 o'clock, but this is past 6. So that has to be in view. That culture has to be there. It has to be intentional. 6 p.m. you close. I'm not shifting, another person takes over. You can't kill yourself with work. So we don't have that culture in Nigeria. So it has to be stated. In abroad, once it is 8 o'clock, you are not there, pam, because you clock in and you clock out. And when it is time for break, leisure, you go out for. If you go out before leisure, you will be penalized. They deduct your money where you are paid hourly. Their wages, they are the paid wages, not the salary. They pay wages there because they pay hourly, daily, and weekly. It's wage. So if you are to work for 1 hour, that 1 hour you must exhaust it. If you come late, if you are earning $17 per hour, if you come late, if you come at, let's say, if you work for 50 minutes, you pay unless you also reflect it in closing by 7, because you came by 8 when you're supposed to come by 7. You came by 8, so instead of closing by 6, you close by 7. So that balance has to be there. Nobody should be cheated. But very important, it must be stated in the letter of employment.
Thank you, and God bless you, sir. Do you have anybody that wants to ask any question from the house?
Yes.
Okay, please, you have the floor, Dr. Olubode.
Good evening, Barrister. Really appreciate that wonderful message topic. My own question is concerning those of us in the medical field. Sometimes there might be situation whereby you started a procedure and you could not finish up before your closing hour. You understand? Like I used to tell my staff, it's not possible for you to leave during such situation. So can you please enlighten me or us on what can be done, apart from giving them maybe compensation for overtime, but in such situation, because sometimes things do arise, situations do arise whereby emergency could just come up maybe a few minutes before closing hour. So what can you say concerning that?
Good evening, Dr. Olugbode.
I'm with you, sir. Hello?
Thank you for your question.
Yes, sir.
Now, I want us to understand some. It forms part of, if you, for example, if you're a medical doctor, or if you're a pharmacist. Now, as a medical, let's say a procedure like you mentioned, a medical doctor is surgeon in the employment of Federal Medical Center or in the employment of First Alpha. These are two, both statutory flavor and non-statutory flavor that I'm using as an example. First Alpha and Federal Medical Center, Abeokuta. Now, you said if you have commenced a procedure, and there are instances, let me even add to your question, that maybe you are called upon on Sunday when there is an emergency. A patient who is, let's say, a patient that is an oncologist patient, for example, who has been operated on and there is a bleeding or something of that nature. Or as a gynecologist, you have just helped a woman to put to bed and then there is a bleeding situation, whatever situation. Thank you. See, let me say this: professionals and vocational employment. Are you with me, sir?
I'm with you, sir.
Should always be hearkened to. As you are, it is a professional misconduct for you to see a patient that needs your attention and you did not attend to her, isn't it?
Yeah.
Good. So professionals and people that are not professionals or people in vocational jobs cannot be compared with people with normal jobs. Now, a person with vocational job knows, because you are taught ethics. Because every profession has its ethics. So ethics ranks higher in employment. For example, as a lawyer, nobody can come here and tell me to forge something for him. Of course, he's my client. But ethics forbids, ethically, I'm forbidden from, I'm never allowed to indulge or assist him in any form of forgery. It's unethical. The first thing that comes to mind is, what is my ethical responsibility? Ethically, I'm supposed to give this patient attention. So ethics comes first ahead of rules of rules of employment, because ethics is very paramount. It is fundamental. So now for your staff that are adjunct staff, subsidiary staff, or staff that join you in the work, there is also ethics regulating their responsibilities. So you get that point?
Yeah, I'm with you, sir.
So that has to be taken into consideration. Ethics. So you put your ethics, the ethics of your profession ahead of the rules of engagement. The rules of engagement says 7 o'clock you close, but you have a patient on the bed. If you step out of that ward, that patient will die. So which one do you put first? Do you kill the patient? Because if that patient dies, of course, you are going in for negligence, medical negligence.
Negligence, yeah.
So you have to, that's why ethics must come first. And if you are not careful, your license will be withdrawn.
Yeah, for sure.
So, I mean, when you look at it, you agree with me that I've answered that question.
Yes, yes, you've answered it, because why I'm saying this, because when you are directing your this thing that the employers can leave employees, you understand, because sometimes you see some of our people, you know, for those of us working in the medical field, some will just think, oh, it is this, or somebody is there to take the shift. Even if somebody is there to take this to take up the work, as far as you started the procedure, it is the responsibility, like you said, ethics comes first. You have to finish up the procedure. That is just why I need to ask that question, so that people around and those that are listening can also understand that when it comes to the way you just explained that some jobs like ours that are professional jobs, there are some certain things that we need to, we are responsible for, like in terms of the way you've just explained. So that's just what I really need the clarification for. So thank you so much, sir.
Thank you very much. So that forms an exception to the general rule.
Yeah.
Of course, every rule has an exception.
Sure.
So this is an exception to it. Ethics. Ethics is an exemption.
So,
Thank you very much.
let me just okay, now, sir, can I just let me just chip in something. Now, you know, the way you've analyzed it, though in my own organization, I have something like constitution that backs this thing. But sometimes, based on the fact that some of them do spend or do spend overtime in the office, you know, they like it's stated in my own constitution, 7:30 you have to be here. But sometimes, you understand, sometimes maybe due to somebody that spend maybe overtime during the course of maybe the day before, the following day, and the person came late. So sometimes I usually just maybe just pardon in some cases. So maybe that could also be applied in some of these rules, because by the time we look at some of these rules, sometimes if we should be going by the rules that, oh, you come late, deducting from the salary, I think some of these people will not be going on with anything. So what can you say concerning that? Should there be some kind of how do I put it now? You know, they usually said temper justice with mercy, and be mercy with justice, something of such. So
yes, I understand what you're saying.
Okay.
But one thing I want you to understand is the fact that
Dr. Rubode, please look into your microphone.
Are you silent here? Yes. Accurate creative. Are you silent? Yes. Oh, we're good. Now.
Hello? Can you hear me? Now, don't forget that we are dealing with humans. The law is meant for humans, not humans for law. But as a lawyer, I will give you the perspective of law. You know, there is always a mischief associated with human conduct. You see, it's better rules are maintained strictly. It is better disciplines are maintained strictly without exemption.
Okay.
But when a peculiar case presents itself, don't forget, part of what we have stated here is incentives. That incentive need not be monetary or pecuniary. that incentive can be very expressed in kind. So there is always a human face in everything. But the reason why there is law is to curb mischief. Generally, human conducts are usually associated with mischief. And that is what law has come to do, to bring harmony. But of course, every case will present itself and will be assessed based on what is peculiar to it. So in this instance, you can look at the effort of the staff in question. You can look at the diligence of the staff in question. You can look at the antecedent of the staff in question. We all know our staff. We know those who display cunning dispositions and character. We know those who are working with their whole heart. We know those who are interested in the monthly salary. We know those who are interested in the growth of the company. We know those that when the company is distressed, they will abandon the company and jump to the next ship available. And we also know those who are willing to go through the company, all through the process and all through the hard times of the company.
Yes.
So we all know this. Thank you very much, sir.
Thank you so much, sir. We really appreciate that wonderful explanation and insight and impactful message. Thank you so much, sir.
Do you have anybody else? In the absence of that, then we'll need to close today's chapter while we meet next week again for the last episode of this campaign, which will be tenant and landlord rights. So we really appreciate those who attended today, and we appreciate those who wanted to attend, but due to one reason or the other, they were unable to. And in a big time, we appreciate our barrister. May God continue to bless him and ease his affairs.
Amen.
So we hope to see you next week again when we meet for another episode. Thank you all. Have a nice rest.
Thank you so much. Thank you, everyone.